When police get a warrant, they get free rein to enter your home in the middle of the night, handcuff you, and go through your most personal belongings. Chicago police left Anjanette Young handcuffed naked in her home while they served a warrant. That warrant was acquired based on bad information from a confidential informant. Anjanette isn't the only victim of sloppy police work that resulted in a warrant. To get the warrant against our clients in Atmore, Alabama, authorities didn't provide any source for some of the most important facts. And Houston detective Gerald Goins made up an informant to get a warrant that ended with an innocent couple shot in their home.
Today comes after a lengthy trial and close to 10 hours of deliberation for the jury in the punishment phase. You'll remember Goins was convicted on 2 counts of felony murder in the deaths of Dennis Tuttle and Regina Nicholas. The 2 of them gunned down in that 2019 Harding Street raid. The raid based on a bogus search warrant Goins obtained with false information.
The Fourth Amendment says that warrants should not be issued unless they're supported by oath or affirmation. But today, police routinely tell judges what someone else told them. The legal term for this is hearsay. Courts started eroding this clause in the 1930s, a trend that culminated in a 1960 Supreme Court decision that washed it away. Now, IJ is asking a federal appeals court to plainly read the Fourth Amendment and require witnesses and informants to directly swear to courts. We are representing Michael Mendenhall, a Denver resident who was arrested and charged with a felony based on a warrant supported by bogus testimony.
It was 9:30 or 10 o'clock, it was dark outside, and I was just sitting here at the counter, and I heard some banging up against our double doors and some loud female voices and shrieking. And I also heard a man's voice that was elevated, that was raised. And I thought, what the hell is that? So I ran to the front door, and I had a bat right next to the door there. It was a bat that was signed by the athletes for the All-Star game here that was held in Denver. So I opened up the door, and I found a couple ladies quickly departing. And I said, what the hell is going on out here? And I said, just get the F off my porch. And the guy just started, really mouthing off and backing up at the time. And so it was a very, very quick encounter, a matter of seconds, 30, 40 seconds.
A short while later, the Denver police knocked at the door.
So they said that there had been an incident that had been reported. They wanted to come in and talk to me, and basically they came in in very short order, handcuffed me, and took me out to the cruiser.
Police used unreliable, secondhand testimony to get the warrant they used to search Michael's office and take his bat. Once they had the bat, they took Michael to jail, where he spent the night. 6 days later, the charges were dropped.
When they decided to not press charges, of course, I was greatly relieved.
Michael's lawsuit could be an important step back to the plain reading of the Constitution's warrant requirements.
I think it's a problem when some random individual with very little credibility can make an accusation and, law enforcement acts on it. And, I am cuffed up and taken to jail, and, spend several hours in a very, very unpleasant, humiliating experience.
We are glad to have Anjanette Young's support for Michael's case. She knows what can happen when police cut corners. Your home is your castle, and the police shouldn't be able to play a game of telephone to get permission to search it.